All right, let's get started. So I gave this similar presentation about 3 weeks ago in front of 750 people, and it was we actually had questions that went on for 30 minutes afterwards. So I obviously didn't leave enough time. There was a little bit of not good plan on my part. So the good thing about it being a small crowd is stop me at any time. And ask questions. I understand that my audience isn't a subrogation audience. All right, I usually speak to people who handle large loss property subrogation, and this is not a subrogation audience. So there may be things I'm talking about. Probably everything is going to be new, but you don't understand or use terms. Stop me, raise your hands, and we'll talk about it. That's number one. Number two, there was a mistake in the brochure. This was a 1 hour class, not a session, not a 2 hour, okay? Now, having said that, the good news is that leaves you open from more choices at 3 o'clock to go to the other sessions, okay? But if you want me to stay an extra hour, I'd be more than happy to. I could talk forever. And when I'm at home, I'm usually stopped pretty shortly. So my name is Richard Gerber. I am an attorney at Evans & Dixon. I was at Brown & James for about 18 years prior to coming to Evans & Dixon about 4 years ago. I started off on the defense side doing civil defense, and about 15 years ago, I was given a fire case. This is how I got into this field. It was a fairly large case. It was about $1 million. And before I know it, I am a fire expert, and I'm a subrogation expert. And I also figured out, I said, well, wait a second here. I was billing out at $150 an hour, working these long hours as defense attorneys do. And I said, well, in this case, we put in a quarter of the time, and the fee was nice, and we're working on the contingency. I think I found a new profession. And so that's how I got started with this. And for the last 15 years, all I do is fire, explosion, litigation. That's it, plaintiff's work. I've got the same guys working with me for the last 7 or 8 years. I brought them over from Brown & James. So we have our subrogation group is 2 full-time attorneys other than myself. And we have 2 part-time attorneys helping out and a paralegal, so we have quite a practice. My practice is a national practice. In fact, I'd say out of our 150 cases, less than 20 of them are in Missouri. I've got cases from California. I've got cases in New York, Texas, all over the country. When there's a large explosion or fire, and large is relative, it could be usually more than $250,000, we're called up, and we are on a plane and we're to that site the very next day with our experts, with our engineers, with our team. We have a team in all states, all parts of the country, and we're there to build the case from inception. In subrogation, this is plaintiff's work, okay? In defense work, you respond. In plaintiff's work, you have to take the initiative. In my cases, your cases, subrogation cases are won and lost from the very, very beginning. If I don't build that case and I don't know what caused that fire and I don't have my evidence ready and know what's going on very early, then it's all catch up and my chances of recovery for you go down. All right?
Rich?
Yes?
Do you do just explosion or does there have to be a fire too?
No, it does not. I'd say of all my cases, I'd say 60% are fire and explosion, water losses, train derailments, a radio tower collapse, almost anything that you pay that's property, and sometimes injuries. Sometimes we'll have a wrongful death case as part of a fire case too. We handle. All right? It's just most of the cases that are large enough, that are catastrophic enough, involve fire. We have a case right now across the street from the White Sox stadium up in Chicago. And a line froze and broke a couple of months ago because it wasn't properly insulated. It caused $600,000 in property damage. That's a typical case. I have a case where wind blew off shingles and caused water damage to a warehouse. $3 million in water damage because 10 shingles blew off. So it caused a lot of damage. So that's product liability and a negligence case. Airplane crashes. And what, you know what, we'll go through all kinds of different subrogation cases, so that'll be part of that. So anything that you pay, we can handle. What I don't do, what my group doesn't do, is auto and uninsured motorists. We have another group in our office, Chris Durso in our office, and he has 4 or 5 people working for him. They handle the smaller subro, the under $50,000, the higher volume ones. So our office handles that. I just don't handle that. Okay, work comp. We'll handle. Now, work comp, we'll talk about that in a little bit. Work comp, you should wait to the very last minute to give that to an attorney, because 9 times out of 10, all the attorney's going to do is coattail the private lawyer and collect a fee on it. So you could do the same thing, hire the attorney hourly just to monitor it, so you don't have to give 1/3 of the money away to Now, on the other hand, if the injured employee decides not to sue and hire a lawyer, then you need to get it to a lawyer, because then we're going to have to do all the work. Okay? So let me ask you all some questions. So let's come up with this scenario. Fireplace catch, it's a home, fireplace fire. Not as a result of the logs burning, but something to do with the fireplace. House is burnt to the ground. You get a phone call from the insured. It's let's just say a $400,000 loss and a couple $100,000 in contents. Who's in charge of that scene? Is it the adjuster or you, if they call you up as the subrogation professional or the claims person? Is it the expert you hire? Is it the insured? Who's in charge of the scene? Does anybody know the answer to that? Well, who do you think?
Insured.
So Joe is with L.L.C. Gas. Joe is usually adverse to me. It's usually, well, before I came to Evans and Dixon, it was Joe that I would sue. So this is a little chess game that goes on between, L.L.C. Gas and me as the plaintiff, or with myself and Ameren UE, or whoever the manufacturer is. So it's very important what happens early on. And Joe said the insured. I think that's partially correct, but we'll get an answer to that. NFPA, anybody know what NFPA is? National Fire Protection Association, you know what it is? NFPA would disagree with you, but I'm not sure that you're not right. Who is required to attend? If you have a fire, why can't, let's make it easier. Let's just say it's a toaster fire. Toaster catches fire, the insured was there, they saw it happen, and it burns the house down. Why can't the adjuster just tell the insured, hey, put the toaster in the bag, don't touch it, and we know what caused the fire? Can we do that? Well, common sense says you can't do that. You'd be surprised how often it's done. What's the role of an attorney? Do you need an attorney? Do you have to give the opposing parties, yes? Fire marshal, fire investigators for the city or county are often there. And the question is, can we rely on the fire investigator for the state or the county or the city? And if it's large enough, maybe the fire marshal to handle the scene and do all of these things. Anybody have an answer to that? Here's my answer. That is the worst thing that as a subrogation professional you could rely on, because more often than not, the public officials will spoil the scene, not preserve the scene, okay? Because their main goal was there criminal activity? Was there arson? That's it. They don't have the resources, they don't have the time, they don't have mainly the resources to investigate the cause and origin of the fire. And as we'll learn in a little bit, although most of the time we could get the origin of a fire at the scene, the cause is a whole different story. That takes years sometimes. Even if we suspect it's the toaster, well, you had a microwave right next to it. You had a can opener right next to it. We have to rule those out. You had arcing on 1, you had arcing on 2. It's not as simple as calling it at the scene, which gets into our expert report issue in a little bit. So to answer your question, they have a role in it, and if you have the right attorney early on, and the right attorney is at that scene or has his experts at the scene, my best friend is going to be that fire investigator for the city or the state. You need to befriend them, because more often than not, they will write a report off their cuff, not thinking it through, and that report can come back and kill you. That's your best friend. You want those firefighters to write reports because more often than not, the firefighters are going to write reports that are undetermined or incendiary, and that will help the defendant. All right? As plaintiffs' attorneys, as subrogation professionals, if you have the right attorney out there and the right investigators, they talk to the public official, don't write a report. Just hold off and let us help you with this. That's a battle that goes on. What is spoliation? Anybody know what spoliation is? Destruction of evidence, right. Can you spoil evidence? And it's not just evidence of what caused the fire. All right? It's not enough just to take that toaster. You better take the outlet, because I guarantee you, they're going to say, if you don't have the outlet, whatever you didn't preserve, that's what the defense is going to look at. That's their job. All these questions right here is what this seminar is about, what this section is about. Who notifies interested parties? Who does that? Is it the insured? We're going to find out. Consequences of public fire department disrupting the scene. What happens when the fire department goes in there and moves everything, either through part of the extinguishment efforts, or they just take everything and they put in the driveway? We're going to address that. Should an expert prepare a report immediately after the fire? Common sense says yes, right? It's all fresh in your mind. It's all, you just got done with your investigation. You got done with your interviews. Do you prepare reports? Everybody say yes. Everybody have an opinion on that? Well, most people, when I asked this question until about 4 or 5 years ago, when I started to do this seminar all over the country, people would absolutely raise their hand, especially the fire investigators. All right? It's not an issue for the defendants because they usually aren't even at the scene until later on. They don't have an opportunity to, which is improper in and of itself. But this is a big issue in litigation, and this is the biggest cause of problems in subrogation action is the reports. I'm not going to give my answer. Well, I'll give it away. It's the very worst thing you could have your expert do is prepare a report. That is the worst thing that could happen to your case. Plaintiff.
You prefer him to call you and let you know?
Yeah, if I want to know what my expert's opinions are, pick up the phone or go meet with them and so forth. Once you commit that, especially early on, once you commit that to a report, now there's issue on whether it's discoverable or not, and we'll talk about that, and the effects of the report, but 9 times out of 10, things change. The target defendant changes. We did testing to determine that item could not have been the first item ignited because its ignition temperature is twice as high as what he thought it was. Witnesses change statements. I could go on and on and on. Most of the time, they don't get it right early on, which is why you want to wait. Plus, you don't need a report. Don't need a report unless you're in federal court. So we'll talk about that. What about communications? When you call me up and say, hey, we've got this fire, and what are your thoughts on this? And I say, something, I've had a lot of headlight fires before. It's a fallacy. They don't catch fire. They don't cause fires. That's not going to be your cause. Don't listen to your investigator. Get somebody else. And you put that in your notes. Is that discoverable? So communications with the expert and the attorney discoverable. We're going to talk about that. This is a little bit more of the same thing. How do we use expert reports at trial? How do we use them in discovery? What's a consulting expert? What's a testifying expert? And we'll talk about that today also. Anybody know what a consultant expert is? Anybody know what a testifying? I know the attorneys do the attorneys may not. Anybody know what a testifying expert is? The difference between the two? Well, you'll find out after today. What's that?
They give their opinion.
They give their opinion, and in all cases you use it too, but are those, if you have your expert prepare a report and he has opinions, is that discoverable by the other side?
Like if you testify, can they be subpoenaed then? If the other side finds out you used them?
Can it be subpoenaed? Yeah, I'll give you the quick answer. We're going to fast forward. That's what this session's about. The answer is no if they're a consulting expert. Yes if they're a testifying expert, and depends on whether or not you're in state court or federal court on what they have to produce. These are all the more reasons why you don't want an expert. I'm not even getting into the details on why even have an expert report. Communications between the expert and the attorney, are those discoverable? I tell my expert,
Depends on consulting or testifying here. Doesn't it?
we'll find out in a second. So here's where we're going. We're going to talk about pre-suit topics and post-suit topics, okay? We're going to talk about the first 5 minutes is going to be about recognizing subrogation potential. Then we're going to get into an area called investigation of the scene, which is really part of evidence retention and spoliation. That's very important. You don't want to blow your case early on. Hiring experts, whether or not to prepare reports. This is all pre-suit issues. And then we're going to get into, is everybody in here Missouri mainly? So we'll talk about who owns the cause of action, what the measure of damages is. When you have a subrogation action, let's just take one of your cases, and somebody runs a red light, hits your insured, and causes $8,000 of damage. And then you hire an attorney to go sue for it. Is he going to sue? Does he sue for that $8,000? Can you get more than the $8,000 if he files a lawsuit? No injuries, just property damage. Do you sue if you guys probably put in an exactimate or whatever you use to determine the damages? Is what the insurance company pays under the policy and the procedures you use to pay that, is that what we sue for? The answer is no. What you pay has absolutely nothing to do with what I could sue for. I'll give you an example. Well, first let me fast forward a little bit, and we'll get to some slides on this. The measure of damages in Missouri is a jury instruction called 4.02. And it basically says that if you find for the plaintiff, you will award them the difference between the fair market value of the property before the loss minus the fair market value of the property after the loss. Okay? Right now, we're going on an American family case. We're going to mediation tomorrow, and the insurance company paid $1.4 million for property damage. Does that mean I sue for that? No. I need to get an appraisal of the property to determine the value of that condominium before the loss minus the value of it after. If it's more than 1.4, if it's 7.5, I'm suing for $7.5 million. What American Family does with the extra money, that's up to you. If the difference between the fair market value before and after is only $100,000, that's the value of your case. So we'll talk about landlord economic loss issue, landlord-tenant issues. Can a landlord sue? Can the insurer for the landlord subrogate against a tenant? Yes or no? In some states you can, in some states you can't. Missouri's a close call. There's something called the implied co-insured argument. If you're videotaping me and I move a lot, my guess is that's going to be problematic.
If you don't go any further that way, you're fine.
Okay, I'll try to stay. I just realized that you keep going up there. Okay, I'll stay right here. So we'll talk about that. Alarm issues. Realizing this is an hour session, we probably won't get to that. Most important, when you're handling subrogation, take off your defense hat. Stop thinking like a defendant. If you're trying to figure out what the other side's doing, you have to think like a plaintiff. This is why defense attorneys make horrible subrogation attorneys. Their mindset is just way off. When you take the typical subrogation case and you give it to your defense firm because they've always handled it for you, somebody who doesn't do subrogation work, they don't get it. I cannot tell you how many cases that I get that I'm trying to resuscitate because a defense attorney handled it for the first year and a half and I'm trying to start from scratch because he wasn't at the scene, he didn't put the experts right. His whole mindset was different on what he had to prove and not prove and so forth. So that's first and foremost. Here are, before we get to the scene investigation, that's going to be our first session, here are the biggest problems that I see in subrogation cases. Number one, and this has to do with one of our sessions that we're going to talk about in a little bit, is a non-cooperative insurer. When you, especially in Missouri, and mainly for Missouri, when you file a subrogation action in Missouri, whose name is it filed in? Who has the right to control it? Well, I'm going to fast forward and we're going to go over the case, but it's the insurer. It's the insurer. If you guys do arbitration forms and you're defending these cases and an insurance company, American Family, brings an action against L.L.C. Gas for property damage, you better make sure that they're the real party interest and they have the right to bring that lawsuit. 9 times out of 10, they don't. Okay, it's just that nobody calls them on it. We'll talk about how to catch them, and we'll talk about how you guys protect yourself and make sure you're not going to get bounced for not having the right part. Okay? If I could just give you the answer real quick, it would take away about 10 slides, so you're going to have to wait. Failure to recognize all subrogation opportunities all the time. I've got one client now who just got rid of their law firm, and they had a pile of piles of files, and they said, look, at all these were rejected either by our subrogation department or by a counsel. And I said, why don't you let us come in and go through those files and look at them? And about 10-15% of them turned out to be great subrogation cases because somebody didn't recognize the subrogation potential. I'll show you some slides in a second. We've got a case in Des Moines, Iowa, and this is a good example. This is a 8-story building right in the middle of downtown Des Moines. It's surrounded by 30-story buildings on each side, connected by skywalks. In Des Moines, you could get from one part of downtown to the other and not go outside because of these skywalks. Do you remember the old Macy's building, famous bar building downtown where they had what was it? The French onion soup, and they were known for that in that restaurant. This was their version of the Macy's building. It was called the Yonkers building, very famous, and even had some historical protections. So they were renovating it from top to bottom, everything, and they were gutting the whole thing prior to, I don't want to give that away. So here's what happened. The last day of work for that week was Friday at 4 o'clock. There was some hot work done, there was some demo work done inside, there was electricians in there was HVAC guys, they had carpentry, they had 20 different subcontractors. At about 12:50 a.m., there you could see the first flames. 12:52, and this is an 8-story building, the flames are seen coming out of the very top of the 8-story building. At 12:52, it's called in. At 12:59, the fire department gets there. 6 or 7 fire departments get there. You can Google this. It was all over the news back then. The entire top 2 floors are completely engulfed. The long and short of it is that the building burnt for 2 days. It burnt to the ground. Nothing's left. I'll show you pictures of it in a second. So I'm there. I get called up the next day, and I'm there. The building spread and caused about $10 million of damage to the building across the street, $20 million of damage to the building on the other side of the street. I was hired for the building owner who had $10 million. There was 5 or 6 other subrogation attorneys there from big firms around the country who do the same thing I do. One of them was Cozen, and Cozen's kind of my competition. Everybody at that scene was concentrating on what caused the fire. Okay, what could it have been? Where was the fire and all that? While they're concentrating on that, because I knew from experience that they're not going to be able to figure out what caused the fire, at this scene. And by the way, nobody was allowed in the scene because ATF took possession of it. They had it for 3 weeks, and during that 3 weeks, more and more of it collapsed. My concentration was on something completely different. I knew that showing the cause of this fire would be tough. They all shut down their files. Every single subrogation attorney firm out there shut down their files. I'm telling my client, I'm guaranteeing you'll get a seven-figure recovery, if not more, in this one. The long and short of it is that we found out early on that there was a security company there that was hired to patrol the building. They were fired the day construction started because it wasn't in the budget. So we took a different stance. This is looking at potential all subrogation opportunities. Would if they had a security guard, regardless of whether or not it was a hot work fire, a loose wire, whether it was a heater, they had 1 million BTU salamander heaters going 24 hours a day. That's what all these investigators are looking at, trying to figure out which one, which I knew was going to be tough. To me, it didn't make any difference. What you should be looking at is that a fire is foreseeable at a construction site. There are a lot of hazard activities going on. You should be looking at how is it prevented. We found out early on that they disconnected the sprinkler system, they disconnected the alarm system. They had 2 prior small hot work fires. They had 2 break-ins, people trying to steal copper. Why didn't you have security? That's how I proceeded. And during that process, we were able to do some modeling and figure out what caused the fire. So the point is that don't close your file just because on the face it looks like it's going to be tough. If you get the right attorney, we'll figure out what caused that fire in a way to recover. By the way, we've already settled with 1 party. I can't give you, it's confidential, but I kept my promise to my client, and we've got 3 more parties to go, and it's going to be a very good recovery. Another deadly sin, inadequate site investigations. You got to do your site investigation right at the beginning. If you don't know how to do it, you got to hire an attorney to do it. It's not going to cost you a dime. If it's a subrogation lawyer who knows fire and explosion and water and catastrophic losses, they're not going to charge you. All the time I hear from American Family. All the time I hear from Allstate. Sometimes I hear from Cameron Insurance Company. They call up and say, hey, we got a fire. They're at the scene right now. We're not sure what to do. And I will, if they don't want to hire me right now, I will walk you through what you need to do to make sure it's protected in case it's determined you got a subro case later. You don't blow it early on. That's what your attorney should be doing for you. You don't have to pay them hourly to do that. They should be doing that for free. And the reason why is that if we get enough of our clients to involve us from the very beginning, even if, I've got one client, Argo Insurance Company, and I handle all their nationwide litigation. Every week we get a phone call. We got a fire in Scottsdale, Arizona, a restaurant caught fire. We got a 7-Eleven in Salt Lake City. We've got a plant up in Flint, Michigan. And of all those phone calls, we'll hire the experts. We're out there right away. We'll do all that. And only if we hit 1 out of the 10, that's still good business for our firm. And it's great for the insurance company because they don't have to go through any of the expense and aggravation, wondering if I'm hiring the right expert, how to do it, how to put people on notice, how to attend site inspections. We do all that. All right? And that's the risk we take, hoping that we'll get good cases. Choosing the wrong attorney, I basically have been talking about the whole time. I'm going to pass that. Choosing the wrong expert and failure to monitor the expert. That's your job. All right? If you don't have an attorney, you better be monitoring your experts. If you don't know how to do it, you got to have the right attorney to do it. Because all these experts, I use that word very, very loose. I'm speaking next month at the Institute of Arson Investigators, IAI, or whatever it is, down the Lake of the Ozarks. I've spoken with them before. I've spoken at the PLRB, where I have a room of 150 investigators. And I'll tell them, you guys are blowing these cases left and right. You're not understanding what your job is. This is litigation. This is an adversarial system. All right? You need to start working with the system. You use your objectivity in determining the cause and origin, but you have to know how to work in the litigation system. And a lot of these experts don't know how to do it, and they will blow your case. So you got to know how to keep an eye on them. Failure to document damages is another mistake. This is the biggest mistake right here. Number 1 is the reports. It kills you. It kills you. Don't have your expert prepare reports. We'll talk about that. So number 1, if you have a fire claim, if you have a water claim, whatever it is, if your insured didn't cause it, there's a subrogation action there. It's there. Now, it may not be cost efficient to go forward. It may be too small dollars, and the expense of the experts and all that may be too high. But in every one of your property cases, if your insured didn't cause it, there is subrogation there. Okay? Whether it's a product liability case, whether it's a negligence case, and you can't keep saying to yourself, well, that refrigerator was 17 years old. It caught fire and it burnt the house down. I can't sue for it. Well, unless they put on their warranty that this is only good for 17 years, and after that we're not responsible, age doesn't make any difference. Is it a factor? Does it come into consideration in the jury deliberations? Yes. But age alone in Missouri doesn't prevent you from filing a lawsuit or from prevailing. So the different types of subrogation, we talked about fire. Fire spread. What's fire spread? Fire spread is my case in Des Moines. Okay? The security company lack of security didn't cause the fire, but they caused it, but by not having one, they caused it to spread. Ansel systems in restaurants, hood systems. They don't operate properly. We had a case, this is a good one, against a municipality. This was a really big case. A grocery store was broken into. This is out in up north in Audrain County. A couple of kids break into a grocery store. They steal some stuff and then they light it on fire. And the place basically burns to the ground. They had a burglar system, they had an alarm system, but what had happened was this, is that in this part of Missouri, ADT or whoever it was didn't have, and this was back before ADT did kind of national monitoring. They didn't have a monitoring office in this part, so they gave the panel, it's a panel that has a bunch of lights on it, 1 through 30. Number 1 is 123 Main Street. Number 2 is 782 Walnut Street, and so forth. And when an alarm goes off, a light comes on, and there's an audible noise. The noise went off, but the light never came on. So the fire department and the police department were never notified, and the place burned to the ground. We found out that the person monitoring this, which was the police department, for some reason, the monitoring company years ago went to the police department, the sheriff's office, and said, look, will you monitor this in your 911 agency? And they said, sure. They weren't being paid or anything. You know about this case by any chance? But it doesn't surprise you.
No.
and they were doing it. The problem is that the people who were monitoring it knew those lights were burnt out. They sent memorandums and emails to the supervisors saying, hey, one day there's going to be a fire, we're not going to know where to send the fire department. So obviously that's a pretty good lawsuit. Now, what was our hurdle in that lawsuit? What do you think?
The hurdle? Well, I'm just going to say, I don't know, for lack of better terms.
Immunity.
Contributory negligence.
Immunity. Municipalities have immunity, sovereign immunity, statutory immunity, 911 immunity. We had to get by all those hurdles. We were in federal court. We had to dot our I's and cross our T's. We won. They filed motions for summary judgment. Got by it. Went to the 8th Circuit and won. Yep.
Pretty limited in that situation, though, wasn't it?
What happened was this, and this is kind of, we're getting to nuances, and this is what happens in a lot of subrogation claims. Most policies of insurance will have a rider that says that if your state has sovereign immunity, this policy will not act as a waiver of sovereign immunity. And the reason why is that many states, including Missouri, has a law that says that you have sovereign immunity if you're a municipality for certain acts, but if you have insurance, its sovereign immunity is waived to the extent of insurance. All right?
Should it also be waived for gross negligence, which is what that was?
Well, this wasn't gross negligence. That's what we would have argued, and I'll talk. That's a very good eye. And let me talk about that in 1 second. Gross negligence is always an exception to any type of immunity. You're absolutely right, but it's very, very hard to prove, especially with the way the jury instruction is worded. But in this case, the broker failed to get that endorsement put into the policy. So therefore, we argued that they waived sovereign immunity. All right. Now here's where the defense attorney made a mistake. The defense attorney filed a motion for reformation, a lawsuit for reformation, saying it was a mistake. It should have been part of the policy, and that was his mistake. He shouldn't have filed asking the court for permission to reform it. What should he have done? Reform it. Reformation means it was a mutual mistake by two people. I don't need court approval. If you say it was supposed to be in there and I say it's supposed to be in there, it's in there, and bang, it's there. That's what he should have done, but he didn't, because once he filed that, then it's his burden to show a mutual mistake. So can you imagine what I did in discovering depositions with these guys? I'm deposing a broker and saying, have you ever heard of sovereign immunity? You know what it is? So how can it be a mutual mistake that you failed to put that endorsement in there when you don't even know what it is? So that's how we ended up winning the case. Anyway, why am I in the third of 103 slides? Okay, so other types of subrogation, wind and roof, inspection cases. You have a fire at a house and you closed 6 months ago, and the inspector didn't properly, inspect the fireplace to make sure that, it's not close to combustibles. So all kinds of lightning cases. Don't keep thinking that lightning is an act of God. Yes, it's an act of God, but just because it's lightning doesn't mean your house should catch fire. Most houses should not catch fire from lightning. All right, it usually catches fire because of construction defects. Okay, we're getting closer to your area because lightning and gases often go hand in hand. Shipping cases, theft cases, roofing failures, all potential. Water breaks, sprinkler systems, sewer backup, all of these potential subrogation. The key is that if you're not sure early on, call an attorney, have a relationship with a subrogation attorney, say, hey, here's what we have. Before I close this file, what do you think? And we'll talk it through with you. It's not going to cost you anything, and we'll determine whether or not you have a chance of recovery. Here's why this is important. There's two ways insurance companies make money, other than in their investments. One is what? Premiums. That's the main way. The other way is subrogation. It's the only way you have income coming in are those two other than your investments that I know of. Failure to supervise. We've had probably 25 lawsuits over the last 15 years where kids at schools flick a cigarette in the field and it catches fire, and then all of a sudden you have $400,000 in property damage. People would think, well, that's an accident. You can't sue a kid. Let's get the insurance policy of the school district for failure to supervise when they know the kids go smoking there and you haven't taken any steps to prevent it. Product misuse, extension cords. So now let's talk about investigations. First of all, any questions? What time did we start? 2 o'clock? We may make this into a 2-hour class. Okay? We may do that anyway. First and foremost, when you have a loss, and usually when I give this session, the people that are here are either claims managers, people head of the claims department, people who have authority over the adjusters, but whoever you are, in-house counsel, it is unless your attorney or somebody else that you believe tells you otherwise, you are responsible for that scene, especially if it's your insured's property. NFPA basically says that the person who possesses the property is responsible for protecting the evidence. Now, you could do that through your experts, but it's your responsibility. And look, only one person's going to pay the price if you don't protect that scene. It's going to be you, because you're not going to be able to subrogate. Unless you have an insured who is injured or you have a death case, even though you may not have property damage, you may have an obligation to that insured, a fiduciary relationship with them where you have to protect it anyway until they get a lawyer and they can take over the scene. But it's your responsibility, and most important is you've got to protect it. If you're in an urban area, get a fence up. In half of our cases, the very first thing we do, and it costs more money, especially if it's a multi-million-dollar case, is that we hire either security or build a fence to make sure nobody gets in there, all right? Because what we're trying to do is protect against spoliation. Prompt action. Take control and talk with the, the very first thing that I do is we call the fire investigators for the city or the municipality. We talk to them. We ask them, please don't do anything with the evidence. We're going to be out there tomorrow. And the very first step is that we hire an expert. We hire a fire investigator. We know who the right investigators are. If you don't, give us a call up. We'll tell you who to use. Those investigators go out. They do a preliminary investigation. They talk to witnesses. They talk to the fire department personnel. They look at video. They know not to disrupt the scene. They're starting to build their case from the very beginning. Usually from their first visit, they know where the fire started and the potential causes are. But that's only step one. So the fire investigators are out there. Let's use our example. Let's use a microwave fire. Microwave catches fire. You have a toaster, you have a can opener, you have a radio plugged in, you have all these things, but for whatever reason, our expert believes it's the microwave. So what's the first thing he does? He gets statements not from your insured. Do not take a statement from your insured. Do not do, because you often get statements. And the reason why is, let me back up. there's a caveat to what I just said. If there are coverage issues, and for coverage purposes, you need to get a statement, that trumps everything. That comes first, okay? But assuming coverage is not an issue, that it's a product failure or a negligence issue, you do not want a statement from your insured, because as you're going to find out later on, eventually, we're going to be filing a lawsuit in your insured's name. So why do I want to start locking your insured into positions? All right? Plus, now you may say, well, that's when their memory is the best and all that. That's when they're more emotional. That's when they don't realize the significance of what they're saying. That's when they run their mouths and say, look, I know that we didn't plug that in because he thinks he has to say that because insurances are going to cover you. They just tend not to say helpful things when you take statements. On the other hand, get statements of everybody else. I'll get statement of all the people at L.L.C. Gas out there. They'll talk. People at Ameren will talk. All the witnesses. That everybody loves to talk to the fire investigators because we make them feel like they're part of the investigation. That's what you want to do, is get statements of everybody else but your own, and the people at L.L.C. Gas, they're doing the same thing. They're investigators probably more than anybody, and at Ameren UE and at all the store companies, they know to get statements of the insured. So it's your job to tell your insured, don't talk, don't say a word. And the best way you do that is to have an attorney and a fire investigator out there. Any questions on that part? Details. Make sure you get the details. Again, that's really up for the fire investigators. Document collection, very, very important. I need to have that lease so I know whether or not there's language in that lease that prohibits me from even filing a lawsuit against an insurer because that state has implied co-insured laws. You don't want to spend money on all the experts and protecting the scene and putting up fences if right off the bat I tell you, look, I saw this lease, there's no way you're ever going to be able to sue the insured under the laws of Montana, so it's not even worth the effort. So gather that information early on if you have the ability to do it, and your investigators better be doing this. Repair bills are very, very important. Hard to bring a product liability action unless you know it was in what condition. The original conditions when it left the manufacturer. So I need to know before I spend a lot of money and time in an investigation whether there were any repairs to that tractor. We're starting to get into a little bit more detail than I want to get into. This really is for fire investigators. But here is what's important to you in the insurance industry. You have to be very careful as to what you write down in your claim notes. When you are doing your investigation back from your office and you're talking to the insured and you're talking to investigators, you're talking to attorneys, you have to know that almost everything you write down may be discoverable. So be careful what you say. Now that's a very general rule, and it doesn't apply in all states. And it may not even apply to your conversations with an expert or attorney, but you have to assume that it will. Okay, you have to assume that at least a judge is going to see those statements when they determine whether or not it's discoverable or not. So watch what you say. All right. So once your expert is at the scene and he's determined that the most likely cause of this fire is the microwave, is that what we said was a microwave? And you have all these other items in the kitchen, what happens? Well, here's what happens. You have to set up a joint inspection. You can't just say, okay, you're on the phone with your expert, he says, I'm pretty sure it's the microwave. You can't say, well, grab the microwave and grab the toaster too, just in case they blame it on the toaster. That's not how it works. You have to freeze the scene. You make sure nobody touches anything. You would think that your experts know this. You would think that an expert who's familiar with NFPA 921 knows this. They don't. They mess it up all the time. But the long and short of it is that you have to freeze the scene, and then it's your obligation to put other people on notice. Either your investigator could do it or you could do it. But when you put people on notice, the very first thing you have to do is confer with the expert and find out who we put on notice. Do we just put on Magnavox, the people who made the microwave? Or do I have to put on notice the general contractor who was doing some work out there about 2 months ago and they put in a new bar? Do I have to put on notice the manufacturer of the can opener? What about the iPhone and the iPad that were up there? Those are conversations you have to have with your expert, but here's the general rule. If you and or your expert think that there's a potential that those product manufacturers could be blamed by the defendant, you put them on notice. Okay? Does that mean anything when that light flashes, or is that just flashing? Here's what we'll do. We're going to make this into 2 hours, okay? Is that all right?
Sure.
You guys okay with that? Because we're only through about halfway. We'll go for about another 10 minutes. We'll take a break, and then we'll for about 10 or 15 minutes, we'll come back and we'll continue. Okay? So you have to confer with your experts. If you have an attorney, they'll know who to put on notice. Don't go crazy with this, all right? For example, in the example I just gave, if the general contractor did work and it's 3 rooms over, and they didn't do any wire or do any work in the area of origin, don't put them on notice. It's just going to take longer and longer to get everybody out there. When you put people on notice, you have to do it in a way, in a letter that is non-accusatory. The letter should be, number one, it needs to be faxed, emailed, and certified mail. All 3 of them. Number one. Number 2, in the letter needs to be very plain and non-accusatory. Dear Magnavox, please be advised, this is how I would write the letter, that I represent American Family Insurance Company, and it's insured as subrogee of Jim Smith. There was a fire on January 5th at this location. You are hereby invited to a joint inspection, and the joint inspection will be held on, and you put a date in that letter. And you write in that letter in boldface that this is a firm date. You must appear at the inspection on this date. Thereafter, the scene is going to be released for demolition. You don't say your microwave caused the fire, that we found an arc on the wire. You don't do any of that, all right? Just a letter to invite them. The reason why you put a date is that if you don't put a date, it will take 3 weeks to hear back from them. Once you put that date in there and you follow it up with a phone call the next day with your legal department and say, hey, I sent you this letter, I emailed this letter, I faxed this letter, try to get individual names too, that forces them to move, because your insured is not going to be happy waiting 3, 4, 5 weeks for a joint inspection. So you have to force the issue. And when they say, I can't get anybody that soon, you say, tough luck. Now that doesn't mean you're going to destroy the scene. But what I do as your attorney is that I say, that's the day of the inspection, that's what it's going to be, and we force them to move fast. We push them. Now, if push comes to shove, and I usually set it about a week out the inspection so they have enough time, because usually they're flying from all over the country. If push comes to shove, and I have a dialogue going with them, and they say, look at Mr. Gerber, we tried, we can't get anybody out there until 3 days later. I'm not going to destroy the scene and face a spoliation action over 3 days. All right? If on the other hand they're saying it's going to take 3 weeks, then I write back saying that you need to get a different expert. Here are the names of 15 different experts. You know, again, the goal here is to protect your insured so that evidence doesn't sit there indefinitely. So you have to be very definite. That's where a lawyer could help. Don't talk about your theory of recovery. Very important to keep your insured apprised of all these steps. You're going to need your insured's cooperation in this lawsuit. When I'm out there with my expert, I invite the insured out, I tell them what we're doing, I walk them through the scene, I say, look, you see this V pattern right here, right behind this gas line, that's where the fire started, it came up, here's our theories. I keep them in the loop because one day I'm going to need them to file that lawsuit. I don't want to file it in Cameron's name. I don't want to file it in the American Family's name. I want to file the lawsuit in the insured's name. This is really beyond this presentation. If you ever get a chance to go to a scene, you should do it. But this is really for the experts, and that is watch your opponent, and more than anything, keep your mouth shut. I tell the experts, stop talking to the other experts and say, I agree that the can opener didn't cause this fire. Don't say that. Because you have no idea when we go to a lab exam, and then all of a sudden we rule out the microwave, and we rule out the toaster, and then all of a sudden the insurer says, come to think of it, the can opener was plugged in, and my wife the other day was telling me that it smelled horrible the other day when she was using it, and all of a sudden, we think that may be the can opener. So and then here's the expert at the scene telling the other experts, he agreed with me, it wasn't the can opener. The experts need to be told not to talk at the scene. We try to go to the scene to make sure that they don't talk. All right, 2 more slides here, and then we'll go to another, and then we'll take a break. Spoliation is a big issue all across the country. Here's what spoliation is. Spoliation basically is failure to preserve evidence and or not make evidence available to other people. I could do a whole hour just on spoliation, but it boils down to one of 3 things. In some states, spoliation is a cause of action. You could sue for it. In Illinois, if somebody throws evidence away, not only can it be used as a defense, you could sue somebody for negligently disposing of evidence. In Missouri, that is not the law. In Missouri, spoliation is not a cause of action. In Missouri, when you spoil evidence, let's just use our example for a second. Let's just say that your expert thinks it's the microwave. All the other experts were at the scene except one. All right, he didn't get a chance to look at the evidence. All the experts at the scene agree only to preserve the microwave and the toaster and the outlet, but they throw away the can opener. If during the lab exams it's determined that that can opener was potentially caused the fire, then here's what will happen. Okay, let's just say that as litigation goes forward, that now the can opener is into play and it's potentially the cause of the fire, and you didn't save it, even though everybody agreed to it. What will happen is that the defendant will get what's called an adverse inference instruction in Missouri. The penalty for spoliating evidence will be this. The judge will instruct the jury as follows. He'll say to the jury that it was the obligation to preserve all relevant evidence. You can assume and infer that had the can opener been preserved, it would have supported the defense of the defendant. Okay, that's called an adverse inference instruction. You could infer that had the can opener been preserved, it would support the defendant's position. Now, what happens if you're the plaintiff's lawyer and you have that jury instruction? You're dead. You're dead. A good defense attorney is going to come up, is going to put that instruction on a big screen, on a big board, and it's going to say, right there, folks, they've been doing this for a long time. Mr. Gerber's been doing this for 15 years. His experts, 30 years as a fire investigator. And they throw away evidence that was 5 feet from the area. This judge is telling you how to consider that. You can infer that had we had that's going to support exactly what my experts have been saying. That's how it is in most states. You get what's called an adverse inference, which is why you can't spoil the evidence. Okay? One other thing, and then we're going to take a break. When you take that evidence, it's all preserved, and it goes to inventory at the experts. Usually they have some type of inventory locker. When you get those letters every month that say, hey, do you want this evidence preserved? Is the case still ongoing? You got to make sure those letters get to the right people. Every year, the letter gets to the wrong person in the insurance company. They look up the case, or they don't look up the case, and they just throw the evidence away. They say, hey, look, it's not my case anymore. I don't see any activity on this case. You don't have to preserve the evidence. That happens all the time with insurance companies. So make sure that if it gets transferred to another department from the claims subrogation, that the evidence retention letters goes to the right person. Let's take a 10-15 minute break, okay? Keep going?
Yes.
So happy hours at 4 o'clock. We'll be the first ones there. Yeah, it looks like. Okay, so now we're really getting into the crux of, and I'm very mindful that not everybody has large cases, and this is a smaller crowd, and some people do auto, some people don't, but for those who do property, this is what it's all about, because it all comes down to the experts. You got to have the right experts, and you don't want to choose that guy. So this is a case. This is the case I was telling you about in Des Moines. That is the Yonkers building right there. This is my client's building right here. That's the EMC Insurance. That's actually their home headquarters. And right across the street, going this way, which is south, is another building that mimics that. And then this is also my client here. This is what's called the Partnership Building, which is a parking garage. So they were renovating this entire building. This is it. This is at 1:15. The fire. I'll talk about it because it's kind of interesting. I think you may get a kick out of this. The fire, remember I told you it was reported at 12:52. Police are there at 12:59. The top 2 floors are engulfed at that time. The bottom floors aren't burning. That's not fire down here. You just see through glow. In fact, you could actually see the lights on right there. You see it? Very significant. That, not this picture, but another picture like that I saw a couple days later. Right off the bat, we ruled out electric, which is good. You know, I want to start ruling stuff out. So if the lights are on, it's unlikely that's electrical, especially with the kind of electrical power they have for temporary. So that's about, I think, 1:15. So it's top 2 floors, top 3 floors now are pretty much engulfed. Fire department, they were in. They got in that building at 1 o'clock. A minute after they got there, they got up to the 4th floor, and then all the scaffolding started to fall. It scared the holy bejeebers out of them, and they got the heck out of there. So it was only a defensive fight. This is the building. It's the whole, now, this is, I don't know when this is. This is probably a couple hours later. The whole building's on fire. And that's it afterwards. That's it 2 days later. Still smoldering. And the long and short of it is that it really goes back to the original slides, the first 5 minutes. If you don't have the right lawyer, somebody who does this stuff for a living, they look at that and they're closing it. Too much work. We're not going to determine what causes fire. As an aside, I could tell you within 6 inches where this fire started. Within 6 inches, we know where this fire started. We know exactly what act. And I didn't even file the lawsuit. What insurance? Nobody's here from the insurance companies I'm suing. I just want to make sure because this case is still ongoing. Actually, we filed this lawsuit for lack of security. That was the goal. So you didn't have security. We're never going to be able to figure out what caused the fire. But whether it was the heaters, whether it was temporary electric, which we know it wasn't, whether it was somebody flicking a cigarette, whatever it was construction related. It had to be because it started from within. Everybody agrees on the general area of inside. Whatever it is, had you had security, it could have prevented it. Remember, this fire spread and did $30 million of damage to the buildings across the street. So that's what the suit started off. First round of depositions were the first in firefighters and the local fire investigator, the local fire marshal, and that's when everything changed. Remember I told you that everybody, when they drove up 10 minutes after it was reported, saw fire burning on the top floors? This fire didn't start up high because when I took the deposition of the first in firefighters and the fire investigator, he hinted to me that fire started down low around the 3rd floor. He couldn't say much because he was under a gag order by the ATF. The ATF took over the scene. At the time of the deposition, his investigation wasn't complete yet, so they couldn't talk about it. And, nor could he talk about anything related to the ATF investigation. What we were able to determine is that there was hot work done near an elevator shaft and stairwell on the 3rd floor. And the manner in which they did the hot work wasn't in an area. Just pretend there is a big I-beam coming out of this little piece that sticks out, 4-foot I-beam. Their goal was to cut that I-beam off. And to get to it, they had since it was completely enclosed, they had to cut an opening to get their acetylene torch in there to cut it. So obviously, we know the area was, and this backs up to a stairwell and an elevator shaft. And the day before this, they just got done demoing the wooden stairs of the elevator shaft and the wooden stairs of the stairwell, and everything was falling down right to the area behind where they were, all that debris, 140, 150-year-old wood, was falling down and piling up right behind there. And of course, we took this guy's deposition, and who was the fire watch, and he didn't follow any of the NFPA 51B requirements. He just did everything wrong. So the long and short of it is, and we have modeling experts, we can model the whole fire. We believe that it started in the elevator shaft, down around the second or third floor, stairwell elevator shaft, because it was all demoed at the time. That the windows, if you look up here, these windows here, 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 and here on the opposite side were weren't replaced yet, so it was open. It just had like that visqueen plastic in front of it. So when the fire starts down low, now keep in mind, my case is failure to have security. So if this thing goes up and burns right away, I got no case. What good does it have security? If the thing starts on fire and the whole thing's caught in 10 minutes, because security usually doesn't run every hour. Well, here's what we also found out, and I'm going to get back to the cause of the fire. We through our work product, we found that the next door neighbor building had video in their food court. There's a food court at the bottom level, and at about 12:33, smoke is filling up that food court. So now I know, okay, we have the ATF saying that the fire is somewhere on the third floor. They won't give us a specific cause. I've got smoke filling up on the next door building 30 minutes before it's called in. And it's really puffing out smoke. So that fire at 12:30 is really going. So here is our theory. Our theory is that it gets going in that stairwell, that since the windows are open up, and that's a complete enclosed stairwell, just like you would see. It's a winding stairwell around all the elevators. It goes all the way up to the 8th floor. Because the windows are out on the top floor, it's a chimney effect, and fire's looking for air. It burns all the air. We also have pictures of the color of smoke, and we've got black smoke. We have white smoke turning to black smoke, which tells us, just so you know, black smoke means that it's getting oxygen and it's burning stronger and hotter. All right? And you can see early on the smoke is white, and then it starts to turn to black. We believe that those windows were out. That's your draft. It draws that fire up. So when the fire department gets there, they see the top floor is on fire. And that's our cause of the fire. And we also have them on the security issue too, because now we know if the guy's doing his rounds, if you see that much burning at 12:30, all right, you would think a jury can determine that it was going for at least 10 or 15, 20 minutes before that if he's doing his rounds, he would have smelled the smoke, and he would have got a fire extinguisher or called the fire department and put it out, because I don't care about this building. I don't care if this building burns to the ground. I care about it spreading to my building next door. That's where the security case comes in. That's what the other attorneys missed. So anyway, that's the anatomy of a $30 million lawsuit. See, this doesn't scare us. Good investigators, we could get in there, we could determine what caused that fire. We could determine, and here's the role of the lawyer in that, and the subrogation person. When the investigator says, something, too much damage, well, hold on a second here. Let's just let's leave the physical evidence alone for a second. Let's get some non-physical evidence. Let's get statements, okay? Speak to people, not in statements. Let's get some documentation. Let's get the daily work logs to see what work was going on. Let's get video. And by doing all that, maybe we could start putting an origin on this, and then we could see what was going on in that area, and we could build a case from that. And that's how we had to do it in this case. So if they would have brought a report early on, and now we're getting the report, so I'm giving it away, then we would have been dead. But now we waited, we did things work, and we did things. We worked it up properly. We waited. We were patient, so now we're in good shape. So the long and short of it is that you control your experts. You have to talk to them when they're at the scene. You have to make sure you understand what they're doing and not doing. Everybody's good on paper, but you really don't know how good the experts are until you talk to the lawyers. They're the ones who know the experts. There are people who look great, sound great, and do a lot of work, and I wouldn't hire this guy for all the money in the world. So you got to talk to it. And we go around just, if it means anything, whether it's in Missouri, whether it's up in Wisconsin, whether it's down in Texas, we'll go and we'll look at your list of experts. We'll do our own investigation if we're not familiar with them. Usually we know the experts, and we'll tell you who to put you on your approved list and who not to put on your approved lists. So, let's go past that. O&C experts, cause and origin investigators, we call them just fire investigators. They're not a jack of all trade. They're not even, origin shouldn't be, cause shouldn't be on there. Fire investigators, cause and origin experts do not determine cause. Okay? They determine origin. That's their job. Today, you need engineers who have the electrical background, who have the mechanical background, whatever it may be, structural background, to come in and help you with cause. And the fire investigators hate. I'm gonna get tarred and feathered when I speak at the International Association of Fire Investigators next month, because they hate when I say that, because these guys have been fire investigators their whole life. They want to write the report and charge $2,000 for a report, and they want to determine the cause of the fire. They're obsolete. Origin, absolutely, because they could evaluate burn patterns, they could do arc mapping, they could do a lot of things to show you where the fire started, but they can't tell me whether or not that arcing inside the microwave is a result of the fire or the cause of the fire. They just don't have that. They can't tell me whether or not a thermocouple would have prevented this from happening if it operated properly. They just don't have that expertise. And that costs them money, but that's just the bottom line. When they're at the scene, ask questions, get information. Before they leave the scene, they say it was a toaster fire. Just talk to them, get information. Tell me what else was in the area of origin. How do you know it wasn't the loose connection in the outlet? Send me some pictures. Let's talk about these pictures. I see some burn patterns over there. Tell me what those are. Just don't get their conclusions. Talk to them about their findings. So do you prepare a report, yes or no? Now, you guys already know what my thoughts are. But as I told you, 90% of the people, when I speak to large crowds, raise their hand. Of course we prepare reports. So let's go through this. I say hypothetical. All these are real cases I've worked at. So I'll call it hypothetical, but it's an actual case. So this is a new car under warranty. No repairs to this car. It's all in the original condition. Still under warranty. It was parked in the garage with the lights off. And we know that because the dad washed his car that morning. It was a Sunday morning. Daughter's birthday, so she was having a bunch of friends and family over. Parked the car in the garage at 10 a.m. after he washed it, and then he was barbecuing all day, so he went right by that car to get out to the barbecue pit many times that day. All the testimony is consistent. Those lights were off. Fire in the garage, burns the garage. This was a house that had, this guy was a hunter, and he would go on these African safaris, and each one of these heads were worth like $50,000 hanging in the guest house. So it was a high dollar case. Cause and origin sees clear burn patterns coming from the headlamp. They rule out everything else. They have a double E out there, so this was a smart insurance company. They had the electrical engineer out there also at the scene. He agrees that it's the headlamp. Do you have him write a report? So they're at the scene, they're calling you and saying, hey, we got this nailed down, we're ready to go. I assume you want us to write a report, and everybody says, yes, write the report. Well, here's this guy's report. This is the conclusion of about a 50-page report. In conclusion, it's my professional opinion that the most probable cause, well, there's mistake number one. Well, that's good, ladies and gentlemen of the jury. That probably did cause that fire to give us, $2 million. By the way, are these reports admissible in evidence? Any report? Yes, absolutely not. No. Testify. Experts testify. They don't bring reports. How can they be used in trials? Only for one purpose. Impeachment. Very good. Let's keep going. The most probable cause of the fire was the headlights came on, stayed on, and overheated. Let me explain what I just said for those who aren't involved in litigation as much. When a witness is there to testify, he testifies verbally and he's cross-examined by the other side. That's what our system's about. He doesn't get up there and say, here's my report, give it to everybody to read. So it really is that simple. Okay, so he says the headlights came on, stayed on, and overheated. I remember getting this report. I've left my headlights on 1,000,000 times. Do headlights cause, what do you mean? The headlights were left on and it burnt the house down? Anyway, is it possible? It is possible, here we go again, I'm asking for $2 million on possibilities. It is possible due to the lamp design within the headlight that one of the filaments broke on either the high or low beam and contacted the other filament, which energized both filaments. It is my professional opinion, that's not the standard, that the most probable cause, that's not the standard, but into something, yeah, and this was I know this, he's passed away, but this guy was reputable in Tennessee. I think this was Tennessee, maybe in Kentucky. Yeah, I know who this guy is. And this guy, everybody used him. He was very popular. I didn't use him, but everybody used him. And he was, he was well regarded by the insurance companies. So this just goes to show you, this is a horrible, horrible conclusion. So, but these guys don't know. He doesn't know how this is going to be used against him. He thinks he's writing this for an insurance adjuster so they could have something for their file. He's not like us. Think, well, wait, I got a lawsuit to deal with here. That's right. No manufacturer data can be taken off the lamp. However, it's believed that blah blah. It was a Sylvania. Enclosed for your use or my photographs. Please call if you have any question. That's a horrible report. Okay, that's a horrible report. And by the way, he's 100% wrong. That's not what caused the fire. When we got this case, which was about a year later, already in suit, and I got this, it was time to designate our experts. Luckily, they saved the car, and here's what ended up happening in this case, once we got the right people on it. There was a recall that Ford had, I believe this was a Ford, let me see if I can remember this right. It was I don't remember the technical term, but there was a switch in the door of the driver's door. Yeah, in the panel, behind in the panel. Some kind of electrical switch. And that switch had a defect. And the defect was this. When that switch got wet, what did the guy do earlier that day? Watch this car. When that switch gets wet, it causes the lights to come on. Okay? So that part is right. The lights did come on. But we found arcing on a wire that was right by that switch. That also, when it energized it, it also sent a surge to right behind the headlight. And that's where the fire, so it made it appear that the fire started at the headlight. It really didn't. It started back at the switch. They ended up paying us almost 80, 90 cents on the dollar in that case. But he was completely wrong. And this is a well-regarded guy. So here's another true case. This is a true case we had. House fire. This is an older man. He was in a lazy boy chair. He had 3 daughters who took care of him. They were all gone at the time. They were trying. Well, I won't give away the facts until a second. They left him in front of the TV when they go to work during the day. They come home at lunch, they make sure he's okay, and then they go back to work, and then, of course, they're home at night with him. Electric blanket fire was what the experts suspected. They also found an ashtray with cigarettes not too far from there. There was a recall on the blanket. This was a sunbeam case. I don't know if you guys have any sunbeam cases. Cause and origin, clear burn patterns coming from the chair, no double E at the time. The guy ended up dying. The O&C only interviewed one of the daughters, and it happened to be the daughter who did less care for him than the other two daughters. Okay, he was confident it was the blanket. This is him calling back to the home office saying, "Hey, you want me to write a report?" And they say, "Yes, I know it's the blanket." Blah blah blah. $325,000 of property damages and a death. So you have obligations here. So it's not just for your 325. There's going to be a wrongful death claim. So you have other reasons to make sure you do this right. You have obligations to your insured. So here is the conclusion of the report. The fire was accidental. That's okay. Accidental. I don't know if you know, under NFPA, there's 4 classifications of fire: accidental, undetermined, incendiary, and I forgot the 4th. Anyway, so that's okay. Then he says the fire originated in a chair in the living room, in a chair. The cause of the fire was either careless smoking or failure of an electric blanket. What do you think I spent the next 2.5 years in litigation fighting? A smoking fire. A smoking fire. Now, had this guy done his investigation properly, he would have found out that he was diagnosed with, it's not emphysema, what's the other one called? COPD. That the family took away his cigarettes months ago, and that everybody else in the house smoked. He no longer smoked. But nonetheless, defense counsel is going to gets this, and I'm finding a smoking fire. Now, there's ways, in retrospect, we could have kept them from getting this, and that is, well, we'll talk about that in a second. You don't use the expert. But anyway, that's another bad report. Another bad report. Elimination of all other accidental natural causes. That's okay to put in there, but that's not improper. It's called negative corpus. There's just things in here that he didn't have to put in. Plus, I wouldn't have him put in here the cigarette butts and debris beside the chair. Is it true? Yes. If they ask you about that when they depose you, you answer the question. But I'm not going to start giving the defense ammunition in your report. This report is supposed to be what I'm going to ask you in direct examination, what my testimony is going to be. If I want an objective report that takes everything into consideration, then I'd ask you to do that. But that's not what this is about. This is an adversary system. I know what I'm going to ask you in direct examination. I know what I want your opinions to be. And to the extent you're going to write in a report, that's what you're going to put in the report, not everything under the moon. Let them go get that on their own. Hypothetical number 3. Okay, now the first fire was a big one. That was a couple million, okay? This one is $325,000. Let's leave the death part out of it for a second. Do you write a report? We're going to answer these questions in a second. Third hypothetical, oven fire, insured's home, only $55,000 dwelling in damages, 20 contents, new oven under warranty, C&O is confident that it's in the oven, no double E. So you decide, look, it's only a $75,000 case. I'm not going to hire an electrical engineer. And that's not a bad decision, You have something under warranty here. You have you have your cause and origin expert. You try to be cost efficient and not hire a double E. So then the opposing adjuster calls you up. You send your demand package over to them. You send it over to Liquid Gas, and they respond, well, give me your supports. Or they respond, hey, something, I'm not disagreeing with you, but I can't just write you a check for $75,000. I need a report. Do you have your expert prepare a report? So 3 different scenarios. Under the third scenario, on a $55,000 case, unlikely we're going to get deep into litigation. Very unlikely it's going to be tried. Under that circumstance, with the cooperation of you or an attorney, okay to have your expert prepare a report. Maybe you'll get the case settled. Maybe Liquid Gas will say, I'll pay you 50 cents on the dollar. Maybe Magnavox or GE says, okay, with this report, you want to get the case resolved. It's a subrogation claim. We could get you 65 cents on the dollar. So that makes sense. But the other 2, absolutely not. Now, here's what I would say first. Under this hypothetical, if I'm on the phone with Sunbeam, no, with what caused this fire? What was the oven? If I'm on the phone with GE, and they say, "Look at Mr. Gerber, we really want to get this case settled, but my supervisor's not going to let me pay without a report." Then here's what I would do. I'm going to write this guy a letter and say, "This confirms our conversation. I told you that my cause and origin expert believes that he found an arc and a wire in the oven, and the oven is the cause of the fire. This will confirm that if I produce a report that says exactly that, you will pay this claim. And if they say, you produce that report, we're going to get this matter resolved, and I feel the vibe, then I would do it." Because most of the time, they're just fishing. Because the defense wants a report. They want you to lock yourself into position early on. Oftentimes, they'll say, "Put something in writing, get us a report, and then we'll consider your claim." Don't fall for that. Don't do it. All right? Unless you do it with how I suggested, saying, "You said the following. You said if I get a report, please confirm this," and then you got to trust it. Otherwise, their whole goal is to get a report from you, because they're way ahead of the game once they get that. So the answer is obviously no. So, but why do people prepare reports? Here's what the experts are going to say. They're going to say, "Well, it's fresh in my mind. How am I going to remember this? My boss wants it. We always get reports." And look at this is still, even though, I'm going to back up for a second. NASP. There's an organization called the National Association of Subrogation Professionals, NASP. Are you a member of it? If you do, and we don't have a lot of subrogation people, but it's an organization that's kind of my trade union, and there are probably 15, 20,000 members. All the people in the subrogation department of the insurance, some of the brokers, a lot of people from the utilities are members of NASP. It is, they do a national conference every year in really nice places where they have about 10,000 people. It's a 5-day conference, 4-day conference. They have regional conferences. I'm the chairman of the Missouri-Kansas chapter. We'll put on a conference every year. They have a list server where on your computer, have you had any cases against liquid gas? This is the second one I've had, and I'm dealing with a guy named Gallagher. Can I trust him? That's kind of how it works. It's, we're people who are in the same business as I am, we pass information back and forth. Or I got a case against liquid gas, and they're hiring this guy named Randy Bickneys. Is he a good expert? What's he like? Does anybody have any of his depositions? So we trade information, just like the defense does with the PLRB, the Defense Institute, and DRI, whatever it's called. And so I would encourage you, to the extent that you're involved much in subrogation, to get involved in that. But anyway, at NASP, starting about 5 or 6 years ago, myself, Jeff Bale, Mark Rodefeld, a couple of other names, who do national big law subrogation, started to tell everybody, stop doing these reports. Here's what's happening. Here's what's going on. This is a defense ploy. And by the way, if you're a defense attorney, you always ask for the report. You say, "I'm not doing anything until I get a report. I don't, you're a lawyer. I don't trust you." But that's the game. And the long and short of it is, don't fall for it. No reports. Even the people on my side of the fence, for all these reasons, up until 4 or 5 years ago, they were still getting reports, and I'd say still half of the insurance companies still do. But the big ones, the more sophisticated insurance companies who have subrogation departments, this is old news to them. They would never get a report. Okay, so the reason why, you need to understand why we don't have reports, okay? Why I don't want you to have reports. And to understand that, you need to know about something called the work product doctrine. The work product, and I'm going to really make this simple. Anything that I do or you do as an adjuster, after an incident happens, whether it's a death, an injury, a car accident, a fire, whatever, once we start working on that case in anticipation of trial, anticipation of litigation or trial, if it's work done towards that, it is protected. The other side in most circumstances, unless there are exceptional circumstances, doesn't get to discover that information. So this gets back to what we talked about earlier. So at my conversations with the expert, okay? My conversations with Joe. Joe, I think they got you. Now let's just say I represent them, that there was a clear, when the guy came out, he didn't cap the line. When he turned the gas back on, I spoke to him. He said he just forgot to. We got some major exposure here. And he puts that into his notes or into his computer, all right? Is that discoverable or not? Well, if it's in anticipation of litigation, and if it's with an attorney or with an expert, it may or may not be discoverable, depending on whether you're in state or federal court. But in general, anything you do or discover in anticipation of litigation is protected. The other side doesn't get it. Now, it's got to be, you just can't say, well, I was in anticipation of litigation. For example, insurance companies, whether or not they anticipate litigation or not, 9 times out of 10, it's their normal practice to send a fire investigator out to a scene, to investigate the scene, and to report back to you. And he may report back to you that, look, we got problems here, we got liability, we don't have a subrogation case, whatever it is. That is not necessarily in anticipation of litigation, especially when they discover your handbook and it says, on all cases, we want you to do a fire investigation and to do a report and summarize it. That's not anticipation of litigation. That's pursuant to your handbook. Okay? So be very careful, all right? Don't assume it's necessarily in anticipation of litigation. We can spend hours on that. So the question is then, if it's anticipation of litigation, it's work product, all right? So this is in the context of experts. There are 2 types of experts. There's a consulting expert and a testifying expert. And the difference between them is very simple. Anything that a consulting expert does in anticipation of litigation or trial, which is going to be the usual case for you guys, they don't get it. So if they prepare a report, they don't get it until they become a testifying expert. So what's a testifying expert? It's real simple. At some point in your litigation, you have to tell the other side who your testifying experts are going to be. And once you name those experts, okay, that person who was a consulting expert is now a testifying expert. And when you're a testifying expert, then the rules change. You don't have automatic protection for the expert report or the communications with counsel. It all depends if you're in state or federal court. All right, so we're going to talk about that right now. All right, so basically a consulting expert is anybody you hire to get advice from, and they stay that way until you say, I want him to testify at trial. And that's usually about halfway through the case. By the way, in federal court, there's a scheduling order that tells you when you have to designate your experts for trial. Okay? In state court, sometimes there's a scheduling order, sometimes it's by interrogatory or a more informal method. So by having a consulting expert, there are advantages of it. Okay? You could share ideas. You could talk freely with your client. You could talk about the pros and cons of the case. If you don't like the expert's report and they're a consulting expert, you tear it up and you throw it away. All right? It can't be discovered if they're a consulting expert. But if they are a testifying expert, here's what happens. Let's talk first about state court. Once you decide to name somebody as a testifying expert, the bottom line is this. It's called the bell has been rung, which means that everything that you have said to that expert, everything that the expert has said to you, everything the expert has considered, anything, it's all fair game and discoverable. The other side in state court gets everything. So that bad report, those 2 reports that we saw earlier on, all discoverable. Even if it's not true anymore, even if they change their minds, it's all 100% discoverable in state court. Yes?
I have 2 questions on your prior slide. You talked about if the consulting experts file a subpoena on the other side. How often do you see that? And then number 2 is how often is the move to quash successful?
I'll give you an example of where it comes up, okay? I had a case in Arkansas, and the other side named their experts. It was a fire case. It was a fireplace case. We were alleging that the defendant, when they put in the fireplace unit, they put insulation, cellulose insulation, up against the flue, and that's what caused the fire. The defense named their experts. During that process, I found out that they had other experts also that they did not name, okay? Consulting experts that they didn't name, all right? Now, if I try to say, hey, I want your consulting experts' information, give it to me, they're going to say, no, it's not discoverable because it's work product. Under certain circumstances, in that case, the expert that they did use relied on photos that the old expert took. So I said, I believe you waived it because your new expert's relying on your old expert. They said, we're not giving it to you. I said, fine, I'm going to subpoena the guy. And I subpoenaed the guy, and I actually was successful. Now, the issue was, in that case, something was even more interesting, is that expert actually called me up on the phone, the old expert, and said, what do you want? What's going on here? Question is, can I talk to that expert? Can I talk to that expert? That is a close call. Most attorneys would say, obviously, you cannot talk to that expert. I don't believe that's the case. You got to look at it state to state. I believe that you can talk to that expert. That expert it's not a client. It's not a party. If they want to run their mouth and talk to you, then they talk to you. Even though I believe that that's the case, I still wouldn't do it. I would still do it by deposition to be safe, but I'm not sure it's improper. Does that answer your question on when a consulting expert file could be seen with requirement? So on any case, let's just say that L.L.C. Gas hires some consulting experts, and they come back and they tell Joe, look, you got major problems here, and Joe decides to defend the lawsuit anyway, all right? If I decide to subpoena those experts, Joe's attorneys are going to move for me to quash that, saying they're consulting experts, it's protected by work product, and they're going to win that. But people try to do it. People try to do it. Always, the good thing about a consulting expert is you're always free to disregard his opinions. You don't even have to talk about his opinions, as long as you don't designate him as an expert. Okay? Now, you can waive work product. All right? It could be waived if your consulting experts talk, okay, especially to the adverse party. There's an argument in many states that you are waiving work product to the extent of that conversation. In other words, work product is meant to be, it's not a confidential communication, but it's meant to be kept confidential. I can't claim work product, share my report with 50 people, and then when you want in the litigation say, no, that's work product, you can't have it. All right? Because I didn't act consistent with it being work product. So the key is don't share your information and work product with other people. There are times that I'll get a case from a client. Oh boy, we got to go faster. I got to go really fast. That I'll get a case from a client. They've already tried to recover. They were unsuccessful, so they send me the file with a report. The report's horrible. I decide to get new experts just to find out that my client has already shared the expert report with the other side. The defendant said, send me over the expert report, let me read it, maybe I'll pay it. They obviously didn't pay it. So now I'm going to be stuck with that expert report no matter what because they probably waived and the other side already has it. Under Rule 26, there's a couple of new changes. If you're in federal court, all right, even though your expert already prepared the report, there's an argument that draft reports are no longer discoverable, okay? So if your expert prepares a draft report, 4 or 5 drafts before he gets to the final one, none of those draft reports are discoverable. Now the question is whether or not a report prepared prior to litigation is a draft report. Some states, there's a case in Alabama where it was determined that that is a draft report, it's not discoverable. There are other states that say otherwise. The big new Rule 26 amendment changes is that communications with lawyers are no longer discoverable. Okay? So even though I name my, remember I told you before, once you name your expert, everything's discoverable, even your conversations with counsel. So if I'm in state court and they're taking the deposition of my expert, and they ask my expert, tell me everything Mr. Gerber told you in preparation of this deposition. I can't object to that. Tell me everything Mr. Gerber told you when you were at the scene. When you told Mr. Gerber that you had issues with whether or not these things can spontaneously combust, what did Mr. Gerber tell you to do in response to that? That's all discoverable in state court. In federal court, it's not discoverable. Can't ask it. Object, can't provide it unless it's regarding compensation. So the bottom line is no reports. We've got 5 minutes. I'm going to go real quick because you need to know this in Missouri. In Missouri, who owns the cause of action? Whose name do you bring the lawsuit in? I want to first explain the collateral source rule, okay? I'm going to be 4 minutes, 5 minutes, and we'll be out of here. You got enough tape?
Yeah.
Okay, we'll be out of here. The collateral source rule says this, okay? Let's just have a real simple case. A guy runs a red light and hits my car, causes $5,000 of damage. I sue him, all right? And I want to put on evidence that not only was he texting when he was driving, but the guy is a multimillionaire. He's got an uncle who owns Anheuser-Busch, and he's got 10 insurance policies. Does that come into evidence? No. Collateral sources, ability to pay, ability to satisfy a judgment doesn't come into evidence. The judge doesn't want the jury to rule against somebody because he has a rich uncle or because he's got an insurance policy. He wants the jury to decide, were you negligent in running the red light? That's the only issue, not how wealthy you are. Make sense? Okay. So when we file lawsuits in the name of the insured, okay, we the jury's never going to know that this is a subrogation action. So in my microwave action, I'll file in the name of Mr. and Mrs. Smith versus GE. The defense will never be able to bring up that American Family is my real client, that American Family is getting all this money. The jury won't know that. They'll think it's Mr. and Mrs. Smith versus GE. That's because of the collateral source rule. Now let's talk about the real party interest in Missouri, who brings the lawsuit. Number one, a property lawsuit is a what's called a chose of action. It can be sold, it can be assigned to anybody. If somebody runs a red light and causes $5,000 of damage to my car, I've got a cause of action against that guy. All right? A year later, Joe comes up to me and says, hey, pay me that $5,000 you owe me from a long time ago. I said, Joe, I don't have any money, but I got this great lawsuit. Somebody ran a red light. Do you want the lawsuit? And you say, I'll take it. I could assign the lawsuit to you, and now you could go sue for what happened back then. It's transferable. It's assignable. Okay? Not personal injury, property damage. Why don't we do personal injury? Because then you're going to have people who are down on luck on their times walking in front of cars saying, hey, I got a great lawsuit. Give me some money, you could have it. That goes back to old English law, and you can't do that. You can't sell causes of action for personal injuries. Okay, and by the one other rule in Missouri and in many, many other states, you can't split causes of action. So if I have a cause of action for property damage and I also have personal injuries, it can't be one suit by the insurance company or one suit by me. It's got to be one plaintiff and one plaintiff only. So let's go over this case real quick. We're going to go fast here, but you got to be aware of this. All right, this is under Missouri. It's called Hager versus Wright Tire. Here are the parties. The plaintiffs were the Hagers. The plaintiff's insurance company was Shelter. Defendant is Wright Tire and Appliance, and their insurance company is Continental. Okay, here's what happens. The Hagers purchase a stove from Wright Tire and Appliance. The stove blows up and causes property damage and personal injuries. The Shelter Insurance Company pays $51,000 for the property. That was their policy limits. The Hagers sue, okay? The Hagers, Mr. and Mrs. Hagers sue for personal injuries and all the property damage, okay? Including what was paid by Shelter. They have a right to do that. Why? The collateral source rule. They're the owner of the cause of action. They sue. They don't just sue for their personal injuries. They could sue for what the insurance company paid them too. Okay? Because the jury won't know that insurance compensated them for that. That's a collateral source rule. That's how it is in most states. All right? So pay attention here. While that suit is pending, Shelter files a subrogation claim. All right? So back at the home office, Shelter writes a letter to the insurance company for Continental Insurance and say, hey, pay this, pay us back, reimburse us. That happens all the day in your field. It happens all the time through arbitration forums or just through negotiations. So you got the lawsuit pending, and then you have the two insurance companies trying to resolve the subrogation claim. The subrogation claim ends up going to arbitration, and Shelter wins. Oh, they settled it for $46,000. So instead of getting the $51,700, they settled for $46,000. Pretty good job. They got 90 cents on the dollar. While that's going on, okay, so after that's done, after Continental pays the $46,000, Shelter gives them a release for their subrogation claim only, not the Haggers personal injury claim. Then the lawsuit goes to trial. The Haggers win. They get a judgment for $244,000, of which $164,000 is for property damage, part of which was already paid by Shelter, and the other $80,000 was for PI. So what does a Continental Insurance say? Say, okay, we accept the verdict, but we already paid $46,000 in the subrogation claim. We get a credit for that. We're not going to pay that twice, right? That makes absolute sense. Well, you know what's going to happen, don't you? Okay, what's going to happen is this. Nice try, the court says, but you don't get a credit. Right appeals, okay? So here's what they say. They say, if you don't give me a credit, I'm paying the Haggers twice. I pay the insurance company Shelter once, and I'm paying them twice. And that is true. It's a double recovery. And what does the court say? Okay, that'll go off after the next two, okay? Shelter only had a subrogation interest. The Haggers were the only party who had a right to sue for the entire amount. Okay, remember the collateral source rules for the entire amount. And the court goes on to say, subro means legal title stays with the insured, equitable title stays with the insurer. The exclusive right to sue stays with the insured while the insured holds the proceeds for the insurer. Let me explain this. It'll take just a second. Here's the bottom line. Here's what that means. That in Missouri, the insured owns the cause of action unless there's one thing happens, unless there's an assignment. Okay, that's the exception to this. So when we get these lawsuits, all right, and we call up the insured, this is why, remember I said earlier on that first deadly sin was not cooperating with your insured, not getting the cooperation. This is why Missouri need the cooperation. Because when we get these cases, we want to go in the insured's name. We have to go in the insured's name. So we will enter into a joint prosecution agreement with them. In other words, say you've got uninsured damages, we've got property damages, we'll split the recovery on a pro rata, but we'll take care of all the expenses. That's usually what we do. If the insured says, I don't want to be involved in litigation anymore, Shelter canceled me, I'm done with them, then what you have to do is get an assignment. You have to get the insured to say, I hereby assign all rights, title, and interests to the lawsuit to Shelter Insurance Company, to American Family, to Cameron. If not, you've got no right, no standing to file a lawsuit in Missouri without an assignment. So from the defense point, look for those assignments, ask for them. All right? I could go on and on and on, and this is a lot more side. Any questions? Well, it's 4 o'clock. Let's go have a drink. Thank you, everybody.
Thank you.
You're welcome.